Order. End of question time. The clerk will proceed to read the orders of the day and notices of motion.
Item 1, resumption of debate on the Court's Civil and Criminal Justice Reform Bill.
The question is that the bill be now read a second time. Ms. Hany.
Thank you, Madam Deputy Speaker. I would first like to declare that I'm a practicing lawyer. As per the Honourable Justice Lee Siew Kin in his opening speech at the launch of the Law Society's Technology Roadshow in 2017, he shared that his view that the world today is faced with more frequent and unpredictable disruptions, and technology holds the promise of greater productivity and effectiveness. We must seize the opportunity to leverage this to higher quality legal services and cost savings for law firms, and ultimately for the clients and society at large. I agree wholeheartedly with His Honour. One of the major components of this Court's Reform Bill is set to empower the courts to conduct proceedings more flexibly by leveraging on the use of technology. My speech today will therefore focus on the potential impact of this digital transformation and explore possible ways to utilize this transformation to reduce the cost of litigation and enhance convenience for court users. Over the past few years, we have begun to see a gradual modernization of the legal industry, from law firms going paperless with the adoption of cloud-based data management systems to smaller setup firms moving away from traditional law firm premises and towards contemporary co-working spaces with shared meeting rooms and lounges. The COVID-19 pandemic has undoubtedly accelerated the pace of digital transformation. By now, most of the workforce, including lawyers, have become familiar with the concept of working from home in compliance with safe distancing measures. Many client interviews as well as court hearings are now conducted virtually, which has allowed more flexibility for lawyers in terms of their daily working schedules while managing other personal obligations. One of my fellow members of the bar shared with me that she had initially thought of giving up breastfeeding her baby after returning to work from maternity leave, but she has since been able to continue doing so due to the work from home arrangement. Another of my peers also remarked that remote working has provided him with more opportunities to spend more quality time and attend to the needs of his aged parents. This reform bill reaffirms the remote working as part of the new norm. But whilst adoption of newer technology to conduct legal matters is the way forward, it is prudent to take heed of the downsides that come along with it as well, such as the loss of in-person communication. Before the start of the pandemic, it was not uncommon for lawyers to bump into our peers in places such as the court's barroom or the waiting area outside the court's pre-trial conference chambers. For years, these ad hoc meetings has helped to foster the productive discussions concerning the day's pressing agendas or aid in the gathering of fresh perspectives on a particular subject. It has also served as an informal way of maintaining connections amongst those in the legal industry. In contrast, most correspondence these days occurs online via video link meetings and emails, and even the actual court hearings are isolated virtual spaces where lawyers are each segregated into their own waiting areas, unable to see or hear those who may be waiting for their own hearings to proceed. Aside from the lack of social interactions brought about by this new norm, the rigidness of the virtual hearings itself has its shortcomings. The currently used video link platform tends to begin its sessions without prior warning and regard for the attendees' presence, which means that lawyers, aside from signing in for their session, do not have knowledge of the current status of the courts unless otherwise informed by the court on when their hearing is likely to begin. Worse still, in events of delays, which may sometimes last for longer than 30 minutes at a time, the litigant in person or lawyer is forced to sit and wait in front of their computer at all times, unable to visit the restroom or make proper use of the downtime for other obligations. To address these issues, I understand from Minister's earlier speech that features on the existing e-litigation system will be further improvised. In this regard, I would like to propose whether the Ministry can facilitate, after taking into account the feedback of users from the courts, as well as members of the bars, to tap on the expertise of the GovTech in improving the features of the e-litigation system or creating a new virtual court platform that is equipped with an integrated chat function and a dynamic queue system. With these features, one will be able to know when their case is slated to be heard upon logging in. With an SMS alert system for the queue, users can manage their waiting time more effectively and efficiently. A private message function will enable users to communicate with the court's admin clerk on the possibility of jumping the queue due to the need to be present for another court matter soon. The chat function would also allow the ability to see other counsels who may be online at the same time and to chat or start a video call with them. This would return some measures of communications between lawyers, whereby counsels can take the opportunity while waiting to explore settlement terms. Although most hearings are now online affairs that require the relevant parties to attend in separate locations, many clients still prefer to do so at their lawyer's office premises. This is common, particularly of the mediation sessions conducted by the family justice courts, where the client still prefers the physical presence and in-person support from their lawyers to ease their anxieties. This arrangement is typically not a problem for medium or large-sized firms, as they have multiple meeting rooms with adequate space at their office to accommodate the lawyer and their client. But for smaller law firms, however, the realities of limited workspaces and meeting rooms represent a significant challenge in addressing similar needs for their clients. In light of the disadvantages faced by lawyers practicing in sole proprietorships or small partnerships, I would like to ask if the Ministry can look into offering some assistance schemes that enable the affected law firms to purchase the necessary equipment to attend such virtual hearings, and whether the courts can provide more spaces that will allow small law firm practitioners to communicate with their clients in person while adhering to safe distancing measures. Over the years, I understand that the government, along with the Law Society of Singapore, have come up with several initiatives, such as Taxcelerate for Law, being subsidy assistance schemes that aim to help defray costs for law practices, particularly the smaller law firms, and enable them to remain competitive. However, these schemes have so far focused mainly on helping law firms to obtain what I would call the software, such as online data management databases and establishing online presence through marketing portals. In this context, would the Ministry be looking into more ways to help these smaller law firms gain access to the equipment or the hardware with the aid of these same schemes, so that they can fully transition to the digital era without transferring the cost of such implementations on their clients? In Mandarin, please. 对许多人来说，诉讼是个既昂贵又耗时的过程。我支持这项改革法案中所提出的建议，例如简化我们法规中的法庭术语，以确保我们的法律易于公众了解和理解，以及利用科技进行法庭程序，以降低诉讼的成本。从中受益者会包括那些受到新冠疫情影响财务状况的中小型企业。接下来，他们可以多利用数码平台来节省时间和金钱，解决争端。除此之外，我希望律政部能够进一步的考虑、审查和建议 法庭所征收的手续费和听证费用，这些改进将会对那些有经济困难的诉讼人或无辜被告的受害者大有帮助。In conclusions, Mr. Speaker, it is my opinion that in order to enhance access to justice, the relevant stakeholders will have to look into and work on the tree house. Firstly, how we can make the law easier to understand for a lay person. Secondly, how we can simplify the court process to avoid unnecessary wastage of time and resources. And finally, how to achieve cost efficiency by acting on the first 2 points. But the last point, which is more often than not the primary concern, because affordability of the cost to be incurred is often the paramount considerations for litigants when contemplating whether or not to pursue a matter further in the interest of justice. I am hopeful that the implementations to be rolled out subsequent to the passing of this court reform bill aims to address these points. I stand in support of the bill.